Welcome everybody to the 2021 end of the year lawyer referral service CLE. Every year we try to put together a CLE that showcases some of the areas of law that are applicable to solo and small firm attorneys, because most of our lawyer referral service members are in solo or small firm practice. Our lawyer referral service is staffed by Donna Birkby, who has been there well over 2 decades, and she is a delight to work with. For those who haven't had a chance to work with her for lawyer referral service, she really does a great job of getting members of the public who need an attorney connected with an attorney in that area. So if you are interested in growing your book of business, please contact myself or Donna Birkby to learn more about the lawyer referral service. We're going to continue to do the TED Talk style CLEs that we have been doing a couple times here in the past. So that's 20 minutes or around thereabouts for each speaker, each topic. And we can have kind of a potpourri of speakers today. We have, I'm stepping in front of the camera for the first time to teach a CLE. That's a new one for me. We have James Boesen, who is an attorney who is now
an account executive and producer
to insurance, an insurance company here in town. We have Patrick McNamara, who is in private practice. We have Emily Sands, who is the private bar liaison over at Legal Aid of Nebraska, and she is co-presenting with Meagan, the development director at Legal Aid of Nebraska. Then we have Meagan Spomer from Nebraska Legal Group, and bringing us home there at the end is going to be Mark Jacobs of Bressman, Hoffman, and Jacobs. So we're going to be going through concepts and ideas pretty quickly. This is end of the year CLE. This is going to be fast paced. And if you have any questions, you can certainly reach out to the presenters to get more information on what they've talked about. I'm gonna lead things off since I'm already on mic and on camera here, and I'm gonna do what I'm calling 20 ways to level up in 2022. Leveling up in 2022, 20 ideas in 20 minutes. There are a few bonus ideas in here, and I will be going through this very quickly. So if you blink, you might miss one of these. Now, this isn't 20 things that everybody needs to be doing, changing in the next year. But if you get a couple ideas from this that you change in your life, in your work, in the way that you practice and live, more power to you. So, all right, here we go. First of all, know your strengths, and specifically here, Clifton strengths. Now, for those of you who aren't aware, Gallup has renamed their strengths finder Clifton Strengths, and it is incredibly helpful to understand what your strongest areas are in terms of how you work well with others, and where you maybe have some holes and need some help from people who have those strengths that you don't have. I myself have taken the whole 32 strengths assessment for a little under $100. You can do the smaller assessment for, I think, 40 or 50 for the five strongest strengths that you have. And really, it's a helpful way to just understand better, this is what I'm good at. And then when you know what you're good at, lean into that strength, use that to your advantage, understand how you can best utilize that in your practice and in the way that you deal with other people. I'm a futuristic, creative planner who looks at things and wants to talk about the future and big ideas and policy. And that's exactly what my strengths finder said. It says that I need somebody else to help me get all my stuff done on time. So I gotta know where I need help too. Okay, next one. Improve your to-do list. We all have to-do lists, but a lot of times what we have on there are big things and not things that are easily done in an hour, let's say. So break down your to-do list into smaller ones so that you have things that you can check off on a regular basis, and keep your checked off things too. That act of checking them off and keeping them on there shows progress. 41% of the items on your to-do list are never completed. So we got to do better with our to-do list, right? So make sure there's specific actionable plans on your to-do list. It's not just pie in the sky stuff. This is what can you do in a given day? What can you do in a given week? Have those 3 different lists. And the biggest thing, give yourself earlier deadlines. Don't put something on the to-do list and say, I'm going to do this, in a month. I'm going to do this in 60 days. Have earlier deadlines. Keep those deadlines and get through. All right. Now, one thing that I'm obsessed with right now is breathing. And you talk to my wife, she'll back this up. I have read a book called Breath by James Nestor. It is really great in talking about how you breathe affects your physiology. It affects how much oxygen you have in your system. And just a couple quick ideas here. When you talk about improving your breath, improve the amount of carbon dioxide your system has in it. Because if it has more carbon dioxide, it will then do the chemical transfer to get more oxygen in. So if you just breathe in all the time, you're not actually getting more oxygen into your cells. You're oversaturating the system in an oxygen-rich environment when really it needs more carbon dioxide in the cells to then pull in more oxygen. So a good breathing tip is 10 seconds in, 10 seconds hold, 10 seconds out, and 6 or 7 hold. You can't hold it as long when you breathe out, but that will improve the amount of carbon dioxide in your system, and that will help you have more oxygen in your cells and in your brain, and it is downstream effects. In general, breathing through your nose is much better than breathing through your mouth. If you can sleep breathing through your nose, you are much better off, generally speaking, than somebody who breathes through their mouth. Please go and read the book. It's a fascinating read, and there's a lot to it. So James Nestor's book, Breath. All right, big thinking. Like I said, this is sort of a Clifton strength for me. Is I like to do big thinking, but in general, sometimes we get too bogged down in small tasks, especially when you're working on a case. But if you have 20 minutes of unstructured, big thinking, daydreaming type time that you can set aside a day to sort of whiteboard, throw out some big ideas, you can have breakthroughs in things that, you didn't even have an idea you were stuck on. You think about great ideas come in the shower, right? You have the aha idea when you're in the shower, or maybe when you're driving. It is that unstructured time of big thinking, of creative thinking that can really help you solve some things that are getting you stuck. All right, this is a tough one because we drink a lot of coffee in the professional world, but I swear this is true. Take out your coffee and swap in 2 glasses of water. Now, I kind of really just knock these back. I don't sip on it. I got to get that water in, but it wakes up the brain just as well as a cup of coffee. And so if you're looking for a way to lower your caffeine intake and improve your body and mind, drink 2 glasses of water right away in the morning. It does work. All right, email settings. It's a tough one, but if you can turn off that notice button, that then every single time an email comes in, you get the ping and you get the email pop-up that you got a new email. Why? Because we are not, as much as we want to be, we are not multitaskers. Our brain does one thing at a time. We may do one thing at a time really quickly, but what happens with emails, it takes us and Susan Koenig's a great expert on this. She's talked about this a lot. It takes us 7 minutes to open that one email, even if it's it's a one sentence response. Stopping what we're doing, opening up that email, thinking about it, responding to it, and then trying to get back to where we were when we were just cruising through our work. It takes 7 minutes. It takes so much time to switch between tasks. And so if we can stop that, oh, I have a new email in my inbox, and it may not be the most important thing, but I'm going to just make it the most important by answering it right now. That is not always best for us. If we manage our email and say, okay, I'm going to have 1 hour of replying in the morning, 1 hour of replying in the afternoon, and then have set my to-do list from then, that's much better than every single time there's a new email jumping to it. It's tough, but it does help make you more efficient throughout the day. All right. We all have the cell phones on the bedside table. Make sure you put the do not disturb, 10 a.m. to 6 a.m. or whatever it is, if and you say, okay, if it's family members calling, that can come through. You can have those settings where if it's emergency setting, emergency call from family member, it will come through. But those news updates that happen in the middle of the night that are pinging the phone, yeah, those can interrupt your REM cycle. So really think about actively setting your do not disturb on the phone so that you're not waking up because of it before you need to get up in the morning. Sleep's important. All right. This is one of my favorites. Old school written thank you notes. All right. It means the world to somebody to say thank you, to say, I appreciate you. I appreciate what you've done. Especially means a lot when it's in written form now that we just use email for most everything. But if you write them out, it will mean the world. And, thanking other people, selfishly, it makes you feel good about yourself. It really is such a cheap way to make somebody else's day better. They will appreciate your saying you're appreciative. So write thank you notes. Get into the habit. Couple a week. You always have somebody to thank. There's always somebody to thank. And going out of your way to saying that thank you is great. If you do an email, that's fine. You got to be genuine with these though. No disingenuine thank yous. This has to be real, from the heart thank yous. Or else, people will pick up on not genuine thank yous, right? All right. I have trouble with this. I'm going to be honest, but delegation. There are tasks that can be done by other people that you are doing. There are tasks that should be done by other people that you are doing. Take time every day to say, what am I doing that somebody else can do that frees up my time to do something that's more important? Staff are there for a reason. Staff can make you a much better, much more efficient practitioner. And delegation is something that really is in all aspects of life, but you are not the hero doing everything by yourself. There are people that can help you. There are things that can help you. Think about how you can work smarter, not harder. This is a simple one. If you haven't, go on LinkedIn, update your profile, show the world what you do, show them what you know. Possible employers are looking at this. Your current employers are looking at this. This is a way to crow about what you're doing. This is about a way to boast what you're doing. It's a way to teach others what you do and what you know. Use LinkedIn more. Update your profile. Make sure it's accurate. Everyone's looking at it. So if they're looking at it and you haven't updated it, you're missing out. So I'll go update your LinkedIn profile. If you don't have a LinkedIn profile, I suggest putting one up unless you're maybe a prosecutor or something like that, where you got to keep a low profile on social media. Everyone else, it's It's looked at, even if you have a web page, they're looking at your LinkedIn profile, right? Okay, here's a task for next year. Join a personal and professional development group. Now, the Omaha Bar Association is a professional group, and we certainly have CLEs that are out there for development and to connect in the community. But I'm talking something more like Masterclass, something like Next Big Idea Club, which I'm a member of, which I love. You know, if you want to learn how to play piano, join an app or a group or an online system that will teach you that. Find a way to expand on your professional abilities or your personal abilities, whatever way. There are groups out there for everything, for anything. You know, if you have a professional interest, maybe it's somewhat tangential to what you do, you know, but it's something that you're interested in, you know, join a group that talks about that, that learns about that, that digs deep on those things. Find a way to dig deeper on things that are really passions of yours. Along those lines, but also separately, find a mentor. Don't have to just find one. You can find two. You can find three. The OBA is a mentoring service system. So if you want us to help find a mentor, we can certainly do that. Or you can just know, you know, there are certain people in the profession out there that you see and you're like, I want to be that person. I want to understand, you know, how they practice, how they live, because I want to be like that. And that may be different people for how they practice and how they live. You know, somebody has a good work-life balance and you are looking for that. Maybe they're a mentor on that. Somebody else is the best practitioner in a specific area that you're interested in working in. Maybe they're a mentor just on that practice area. But reach out to them, ask them out for a cup of coffee, ask them out to lunch, pay for it, pay for their coffee, pay for their lunch, follow up with a thank you afterwards, and pick their brain. People are willing to be a mentor to you if you ask. And it doesn't have to be this formal thing. You can ask them out, you know, for coffee and just say, hey, I want to learn about this that I think you really understand a lot. And then on the, you know, the other side, you can be a mentor to somebody. You have something to teach somebody else. Trust me, each and every one of you can be a mentor to somebody else. It can be in the profession. It can be support staff. It could be a law student. It could be family friend, a child, or somebody in the community. A neighbor. It could be. There are so many different people that maybe they ask you a question. Maybe you see that they, you know, they have questions that nobody's answering. Invite them out to lunch, pay for it. Invite them on a coffee, pay for it, and have a chat with them and see if you can help them by being a mentor. All right, this is actually from somebody who I consider a mentor. This is an idea from Dave Houghton of Houghton Bradford Whitted, former OBA president, former NSBA president. And it is get a journal, blank, and inside just start writing 3 pages in a row. There's no stopping. There's no thinking about what you're going to write in advance. You get there, you start writing, and you write until you're done with 3 pages. You do this in the morning. First thing you get up, this is one of the first things you do is write those pages. And it's just 3 pages, no matter how long it takes. It can be about anything, but just get it down. This is less of a diary type thing. This can be more, you can write creatively. You can write not necessarily about yourself. You write about other things. You can write about anything. So there's no limit on what you can do with these pages. This idea comes from, is it Julia Catron? I believe her name is The Artist's Way. Julia Cameron, The Artist's Way, and Dave Houghton was the one who talked to me about it, and it is great. All right, next, Yeah, that's you, me, and everybody, right? Get home, take off the pants, sit on the couch with some chips, right? Now, in 2022, can you, just for one night a week, find a new activity that you're doing on a regular basis? Maybe it's a book club, maybe it's golf league, maybe it's um walking outside, maybe it's just reading a book. But change one night of sitting on the couch watching TV, snacking, with some other activity once a week. Start small, it's just one night. It's not changing everything about yourself, but one less day in front of the TV, one less evening in front of the TV could improve things. Maybe it's meeting up with friends. Maybe it's a dinner party, or going out to dinner. Maybe it's cooking out. Whatever it is, cooking at home can be extremely meditative and good. If you don't cook at home, one night of cooking at home, hey, that's big. That's helpful. All right, this one. So take a colleague, say, hey, I'm going for a walk around the block, or I got a 20, I need to take a 15-minute break. You want to go on a walk with me? And go for a walk. It could be inside the building, it could be around the building, but having conversations with colleagues about work, where you're having those conversations one-on-one, but you're not necessarily looking each other in the eye. You can actually dig deeper on some of it. You can get to some stuff that maybe it's tough to talk about, but it also gets the brain flowing. And so if you're trying to come up with an idea, get up, walk around. It's good for the body, it's good for the mind, and it could also be a breakthrough that if you're sitting across from each other, sometimes that's not felt as cooperative, that's felt more confrontational. But if you're walking together, it can be a more cooperative feeling. All right, this is a big one. Things get more heated these days, political, what have you. Understanding, and we do this a lot, but try to do it even more in work, in life, in family, and everything. Lead with empathy. Try to understand as best you can that other side that you're shaking your head at, that you can't bring yourself to even fathom what they're doing and why they're doing it. Instead of being quick to anger, try to lead with empathy. Putting yourself in somebody else's shoes. It's such an important characteristic in life. The more you do this, the better off you will be, and the work that you do certainly will be. I just think so much about how Judge Smithcamp was an incredibly empathetic person, and how that really bled through everything that she was, and how we just herald her so much for how incredibly empathetic of a person she was. And it didn't come easy to her. She was an introvert, but she also cared a lot, and it is important to, as much as you can, lead with empathy over anger, over ego, anything like that. All right, this is the Scott Frost line when it came in. First year, it was, don't be afraid to fail. I love it. I love saying, instead of, why should we do this? Oh, I don't know. I mean, we could fail, there's a million reasons that something can't succeed. I like to say, why not? Let's push ourselves and not be scared that we may fail and never actually do what we can do. So don't be afraid to fail. Meditation. I have a few different meditation apps. There's Aura, there's Calm. Those are about $70 a year. Headspace, it's another app, $75 a year. You put this on your phone. There's the Insight Timer, which is a good one. Peloton, if you're a member, that has meditation. there are plenty of ways to, on your phone, find a meditation app, find a meditation video or podcast, and take 10 minutes, 15 minutes, and focus on the breath again, and meditate and relax, and take yourself down a few notches. Think more about what is going on in your life, move past the grudges, and meditation, I think, is so underutilized, and I think the benefits are incredibly huge. If you're interested in more on this, I did a bar talk about a year and a half ago with Jeff Bloom, who's a local attorney, talking about mindfulness and about meditation and yoga. Really good stuff on that. All right. This may go without saying, but again, we're living in the time, people are hardwired now with hair triggers. I'm going to take it the wrong way. You say something in email, I don't know your inflection. I don't know what you mean by that. If you pick up the phone, I'm going to understand cadence. I'm going to understand volume. I'm going to understand inflection. You learn more about what they mean when it's in voice, when it's on a call. You learn the most when you're in person and you're talking with them. You can see their face and you can hear their voice. But in text communication and in emails, you don't always communicate the way you want to. Somebody could take offense to something that you really meant no offense by. And so when in doubt, pick up the phone. You could actually save yourself a huge headache by talking about on the phone and then following up the confirmation email on what you talked about on the phone. So instead of just back and forth emails that will run up the bill, pick up the phone. All right, here's a challenge. Set 3 goals, specific measurable goals for 2022. Now, we've talked about a lot of things here today, and there are a few more slides, but set a goal that you can measure. Maybe that's, running an average of 20 miles a week. Maybe that's reading 10 books in the year. Maybe that's lowering your heart rate, your average heart rate, if you have an Apple Watch or a Whoop or some other sort of system that can measure your heart rate. Maybe you're trying to find a way to be healthier in that measurable way. You can do that through breath as well, lower your heart rate. So come up with 3 goals, write them down, make sure they're things that are measurable, and start working towards those, and review it in December of next year. Review in December 15th next year, not quite here at the end of the year. All right, that was 20, but we got a couple more. I always think volunteering is one of those things that makes you feel better about yourself, but it's also good in helping other people. Giving a few hours to volunteer at Legal Aid of Nebraska, Volunteer Lawyers Project, Soup Kitchen, like Barney is doing here in How I Met Your Mother, Big Brothers Big Sisters. Really, there are a million ways to volunteer, or there's the tenant assistance project right now for people getting evicted down at the courthouse. There are a ton of different ways to volunteer, and it can mean the world to people you're volunteering for. Serve on a board, whatever you want to do, but it'll come back. You'll appreciate it in spades, volunteering. All right, we're getting near the end. I got 2 more slides. First one, understand how you learn best and lean into that method. You may not be somebody who learns best by reading. You may learn best by talking it out. You may learn best by by writing it. Understand how best you learn and lean into that. I love listening to podcasts. I don't get much out of videos. I get a lot out of listening. Okay, so for me, I'm more of a podcast person than I am like a masterclass video person. I All I need to do is listen. I don't need to see it. Reading, I'm not the best reader. I'm sorry about all the books in the background, but I I learn more by listening to a podcast by an author about the book that they've written than necessarily reading the book. So understand, how do you best learn, and then lean into that. Try to learn in that way about the things that you want to learn about. All right, last slide. Know when during the day is your sweet spot, when you're most productive. That could be mid-morning, that could be first thing in the morning, could be 8 o'clock at night. And do your toughest tasks then. Don't push out the toughest task at the end of the day. If you're like me, 3 o'clock to 4 o'clock, gosh, I don't get a lot done. It's not a productive hour for me. But you know what's a really productive time? 9:30 to 11:45 in the morning. I can get a lot done in that time compared to I can get done 3 o'clock to say 7 o'clock at night. There are just certain times when you can get more done when you're a better worker, better thinker. Do your toughest tasks then. Have your easier tasks at the time when maybe you're not at 100% mentally or physically. All right, that's it. That's my 20. Well, it was like 23 ways to level up in 2022. Thanks so much, and I'm gonna get the next speaker out here. Thanks, everybody. Welcome, everybody, to another of our 20-minute quick hits with James Boesen. James is a longtime OBA member. He practiced in insurance defense, commercial litigation, and now he is with Marsh McLennan as a risk advisor to businesses large and small and in between. And with that very unique background, we're going to pick his brain about some things that we can pay more attention to, advise our clients better on when it comes to risk, to liability, to things like that. So I'm gonna turn over to James and see what do we need to be advising better with our clients.
Thanks, Dave. And hi everybody. As Dave mentioned, in my current role, essentially helping clients negotiate and place insurance products, and also kind of advising in a consultancy capacity about where are our relative exposures, and how do we transfer risk, and how are we maneuvering within the world now with all the various exposures that are out there, both on a first party basis and then contractually with our vendor partners and our various contracting partners along the spectrum there, and just helping as an advisor that works with both clients and their attorneys across the board, making sure that we kind of both understand our total risk in any given scenario, and then understand where we might want to pass some of that off by contract or by insurance product placement, and also just kind of understanding the climate when it comes to both capacity and rate issues, for more strategic long-term planning on both the budget side and for long-term contracting, and just kind of overall risk portfolio management as a company. As the companies grow, those items can change, as I'm sure many of you have seen. And so really it's just about having an ongoing conversation with our shared clients in my space with their attorneys and other advisors to make sure we've got a grasp on what may be in the weeds out there and how do we best protect against it. Yeah. So, in general, Dave has asked me to, comment on a few items. I'd say in general, the conversation today is more of a high level, what are we kind of seeing? How do we as attorneys interact with our clients, in an advisory capacity on several different risk related items? Obviously, each of our clients are going to have unique and specific needs. So this would be my plug that if you've got specific, items to discuss, you should be kind of bringing in risk managers with your client, and then also talking, to the broker or legal partners that you work with on those items. So, in general, Dave's asked me to kind of cover what are the coverages that most businesses really across industries and, of any size, what are they generally looking at as far as their own coverage and maybe what to expect out of their contracting partners. As far as, what are the coverages that most businesses have exposures to and where are they placing, insurance products? There's kind of three buckets that we look at. You've got, first bucket is coverages that are going to be required by law. So in the state of Nebraska, for example, and generally in most states, the two main coverages required by law that most businesses are going to have an exposure to are going to consist of workers' compensation and auto coverages. So most states have codified minimum requirements in these spaces, and essentially they're required whether we like it or not. As a general piece of advice, if you've got a client that's got W-2 employees, they're probably required to have work comp. Now, there are various carve-outs for volunteers and domestic workers and ag-related items. But in general, if you've got employees, you're required to have work comp in the state of Nebraska. Work comp is relatively easy to understand and relatively easy to place. So, not a ton to go into there, but work comp is going to be coverage that generally would cover both medical and indemnity for an injured employee. So our medical component, we're paying for their injury that was sustained in the course and scope of their work. And then indemnity would be essentially lost wages. So, there are some other items that tend to be included there. But one of the great bargains, depending on who you ask, I guess, how great that employers have made over the years is that they have agreed to statutory protections as far as their liability and the limits of their liability with their own employees. But the trade-off is that there's essentially no fault coverage provided by most work comp policies for employees in the course and scope. So you can't sue us under general liability theories, but we've agreed to pay for some stuff that is going to have a no fault or not at fault component as well. So that coverage is, managed by the state through the Department of Insurance, and the coverage forms are generally identical across carriers and will cover the statutory required components for an employer. So the other item that most of us have an exposure to as businesses, whether we know it or not, is auto. So if you've got company-owned autos, it's relatively straightforward. You're going to have to cover those by law if they're out on the road, doing business for the company. Kind of a lesser thought of coverage that loops auto in as well is in what we call hired and non-owned auto. So essentially, if you've got any employees that are doing business in the world and they're driving their own autos, they're driving rental cars, they're driving anything on the roadways for a business purpose, we want to make sure that there's coverage there as well. So, any autos that you own, you've got a legal obligation to provide liability coverage on those autos, but also as far as an employer strategy, really, if you don't have a traditional auto policy covering owned autos, then you certainly need to look at hired and non-owned issues for liability that maybe we don't think of, where Dave goes to pick the mail up and hits a busload of kids. We're going to have some liability there as a company, and certainly that's one that we would like to transfer the risk and not take on ourselves.
That's when you added, I believe, that we didn't have for many years, actually. So you helped us plug that hole with the liability exposure at the OBA. So yeah, I should say that we're a client of James's. So yeah.
Yep. So kind of the second kind of bucket of coverages that we run into on a day-to-day basis would be those that are generally required by contract, whether we're imposing those on other folks that we have business relationships with, or whether we're entering into agreements that have requirements that we need to meet in order to fulfill our contractual obligations. Usually general liability is going to be one of those coverages that, it's of course advisable for all companies, but also may be required by most of the contracts that we enter into. General liability, I think is what most folks would consider when they say liability coverage. I would say that general liability, sometimes I think folks and business owners especially assume that general liability covers them for all sorts of liability that it generally does not. So main thing to think of when we're thinking about general liability is that it's not this catch-all that it's easy to assume sometimes, where general liability is mostly going to be limited to bodily injury or property damage caused by the negligence of the business or its employees or agents. So, really, I think it's useful as attorneys and advisors to really, when we're thinking about general liability, try to think of it in more narrow terms than we maybe traditionally have, because there's a lot of items, whether it's economic damage, whether it's delay, whether it's, any sort of items that we think about that our clients could be sued for. A lot of those items do not fall in this general liability bucket. So if we hurt somebody or if we hurt somebody's property, GL is intended to cover that. If we hurt somebody's feelings or we breach a contract, it's not generally for that. So, some other items that are generally included in contractual requirements would be errors and omissions or professional liability, especially in the services industries. If you're providing a product or service to your clients that maybe has a very low risk of causing bodily injury or property damage, but a real risk of causing, delay or economic damage, we're going to pick those up outside of that general liability bucket. And usually that's in the form of an errors and omissions policy or a professional policy. So easy way to think of that is, let's say I sell the Bar Association, a software product, and that product doesn't do what I've agreed that it'll do by contract. And, Dave gets to sue me for $1 million. Well, there's not been any property damage or bodily injury. So general liability is going to say, do not pass go. So generally where we'd pick up an economic damage by breach of contract in a situation like that would be an error and omission or a professional policy that would cover those items that are not covered by general liability, but that could nonetheless cause a loss for our clients that they're going to turn to us for coverage. So, a good question to ask at the outset on any of these contractual items is, what are we providing and what are we trying to protect against in the event that something happens and we can't fulfill our end of the bargain. Another item that kind of rides along with those policies as well is you're generally going to see an excess or umbrella component. Usually this is a function of a contracting party wanting higher limits than a traditional general liability or professional may provide. Standard limits on the base layer for most coverages is going to generally be about $1 million, sometimes a little bit higher, hopefully not lower in many instances. And that excess umbrella tier usually sits over some of those other coverages to provide additional limits and ideally would match the coverage form of the underlying limit. So your trigger is going to be the same. So those are kind of our, required either by law or contract. The third bucket is kind of those coverages that are, best practices or certainly advisable in today's business climate. The one that comes to mind, I think, for most folks immediately is going to be cyber insurance in that space. So, what we see is that we've got a lot of business clients that assume that they don't have much of a cyber or technology related risk because that's not the main business that they're in. And a lot of our clients have learned the hard way that is just not the case. So the amount of business that we transact, over obviously computer and other technological means these days, is just something that cannot be overstated. So, essentially, if you're paying anybody or if anybody's paying you, if you have an accountant, if you have a computer, you've got a cyber risk. So that's an area that I think traditionally, some of our more blue collar clients have not thought that they necessarily have as much of an exposure. But some of those small to mid-sized clients in what I would consider more blue collar trades or industries, we've seen actually targeted more so in some instances than, kind of what I would call boring office type companies. So, we've had construction companies that have, plans and estimating softwares that are locked up for ransomware. We've had a lot of contractor related, vendor items where we've got dummy invoices or, phishing attacks that you've got folks that they're paying large construction draws, to a fraudulent party. And really any company that's got an email system at this point is subject to, certain phishing and ransomware type items. So again, not something that's necessarily required, although a lot of contracts are starting to require cyber coverage, as another basic requirement. But certainly it's an area that needs to be reviewed, and generally placement through an insurance product is the best way to protect against that. But making our clients aware that the cyber risk is not just for software companies or tech companies, I think is a major item and talking point that we should be hitting. Another area along with cyber that we've seen a large increase in is employment practices liability insurance, or EPLI for short. So in general, EPLI is going to cover first and third party claims related to the behavior of our employees, or sometimes the behavior of our employers. So traditional areas for EPLI that we would see would be any issues related to hiring or firing, as a first party coverage, protecting the business. That's going to cover us for wrongful termination, discrimination, other protected class type items, where oftentimes the value of that policy is going to be investigation and defense. So even if the business is ultimately not held liable and is not required to indemnify an employee, those coverages often include cost of defense. So anytime that you've got a company that has hiring and firing, as a regular function of the business, that's a coverage that we really are advising, because as we know, society as a whole has become more litigious, and certainly terminations can be situations that lead to claims, whether those are meritorious or not. So
yeah, I just say from the OBA perspective, lawyer referral service, we are getting 5 calls a day about that area. Again, not certain if they would go that far, but you have a lawsuit, you got to defend against it. So it is certainly there. Yeah.
Yep. And then another component of many EPLI programs as well is going to cover us for third party claims caused by actions of our employees. So, if we've got employees that are in the world representing, our clients, their behavior is going to oftentimes come back on us. And while, there are certain, intentional act exclusions to various, vicarious liability rules and laws, a lot of items that our employees do are going to be ultimately our responsibility as employers. And so to the extent that we may have employees engaging in harassing behavior to the public at large, or they're interacting really with the public in any capacity, that coverage is going to protect us from employees that end up making bad decisions that could reflect poorly on the company in that regard.
Yeah.
So, as far as the kind of the universe of products are obviously thousands and thousands more, but in general, those are kind of the items that we're seeing utilized by most companies, regardless of industry.
It is just a curiosity here. Is there any increase in key employee coverage, anything like that, with potentially people, having illness that's going to get them out of the workplace? Is that changing at all, or is that kind of static and still where it was before, or is it pushing down to maybe smaller businesses than it once was?
So I think your question is kind of taking us into a discussion that would be more on the employee health and benefits kind of side of my business. And again, it's part of the overall kind of, risk equation. As far as how are we incentivizing and protecting our own key employees, that's generally more of a compensation and benefits type discussion than kind of a traditional business insurance question. Along that front, though, I would mention that any companies that have multiple owners, or that certainly have a board of directors, or outside investment, whether that be private or public investment. Your question about key employees, it made me think of, directors and officers insurance is another area that a lot of folks maybe are not familiar with. But that helps us protect, our C-suite and a lot of our operations executives and key employees for their, vicarious liability, on behalf of the company, but also any personal liability they may have for their actions in a corporate leadership capacity, whether that be fiduciary or just kind of general business decisions that they're making that may lead to a claim, whether that be from disgruntled investors, other owners. So yeah, that's more of a kind of boutique type coverage to protect certain businesses. But I would say in general for our business attorneys, that they, I'm sure, are aware of those types of issues. But yeah, any time for me when I'm working with a client that has any sort of ownership splits, other than essentially closely held with 100% in one entity or person, we do recommend reviewing what are the various business interests here. Are there public investors? Are there donors in the case of a nonprofit? So the Bar Association, for example, has a directors and officers policy that helps cover our volunteer board at the OBA. It would also cover Dave and other leaders personally if there were to be mismanagement or other claims that were brought against the organization, but that may have an individual component for our key employees.
Yeah, no, that you took a bad question and turned it into a great answer, James. That's the sign of a very smart person there. Another aside, I thought everybody that dealt with insurance looked like the guy from Groundhog's Day. Bing, but you don't present yourself like that. You actually know what you're talking about here. One question, if you're going through the process and here's a claim, somebody's brought a lawsuit against you, your insurance is going to cover it. Do you have any control in that process of who they hire, how they go about that? I mean, can the general counsel of a company or an outside attorney that represents the company help with that process? Or is it really, you're putting it all in the insurer's hands to find the right counsel and do that work? And they're just asking you for information and things like that.
So as any good attorney answer, Dave, I think the answer is it depends.
Oh, there it is. There it is.
So I would say most standard lines of coverage and most coverages that small to mid-sized businesses are going to have are not going to have a choice of law clause. So generally, as part of the agreement with the insurance company through the insuring agreement, the client or the insured is going to cede some of their rights to the insurance company when it comes to defense and indemnity type issues. So I would say in general, it's always important to have stakeholders within the company or, certainly corporate counsel or in some instances outside counsel, participate in that claims process. By and large, most insurance carriers are going to have preferred, counsel. And, I would say the more boring, for lack of a better term, the claim is, the more likely that you're probably going to be, to some extent, at the whims of the insurer when it comes to counsel. I would say that as policies scale and, the larger businesses that you're working with, or the more kind of specific or unique the coverages that are being provided, oftentimes those will have more flexibility as far as choice of choice of counsel. And so, a lot of times professional policies or other kind of claims made policies that are, generally professional or legal type issues, think of legal malpractice, medical malpractice, many of those policies will have a choice of law, or even in the absence of a choice of law clause, or I keep saying choice of law here, I mean choice of counsel. Those insureds will be more likely to either utilize, handpicked counsel, or at least be more involved in the decision-making process. I would mention as a caveat to my comments here that almost every insurance policy will allow you to hire your own attorneys to represent you at your own cost, that have a right to participate. So if for whatever reason, whether it's an extra set of eyes, whether you got some extra money to burn, or for any number of reasons, if you don't feel that the panel counsel assigned by the insurance company is doing an adequate job, or whether you just want an extra set of eyes on, then most policies will allow you to certainly hire your own attorney at your own cost to participate in that process. So
isn't choice of counsel for legal liability, isn't it always Clarence Mock, or is that just that's just what I see, I guess, when I'm reading all those.
I know a number of firms in town that don't think anybody can do as good a job as they themselves can. So I know that can be a discussion with our legal malpractice partners at times.
So in terms of coverage, are you seeing, I mean, are people lessening their risk? I mean, there seems to be more risk all around these days, but are you finding people be a bit more attuned to what their needs are coming into your office, or you having to educate them start to finish? I mean, how's the sophistication of the business climate here in the Omaha area that you've seen?
It sometimes can be industry specific, and a lot of times it'll come down to the particular buyer or client for us. I do think in general there are a good number of sophisticated buyers. Certainly companies that are large enough to have a C-suite that will have a dedicated CFO, controller type position, or the companies that are large enough to have a full-time risk manager certainly are reviewing these items, more so than maybe folks that, have a small group and are relying more on third parties. I would say in general, there's kind of a misconception that among a lot of clients that, as prices increase, we can just take on a little more risk ourselves or put more skin in the game, and that things will necessarily be cheaper or easier. And I will tell you that is not the case. We do have a lot of, clients that as they become, more sophisticated and larger organizations, they begin to think that as their procurement strategies in insurance either cost more or becoming more complex, that, they would like to see generally cost savings through additional risk transfer or, self-retentions generally. I would say generally leave the self-insurance to companies that are probably making over $1 billion a year in revenue. Yeah. So, most of our clients are not in a financial position to really take on a substantial amount of self-insurance themselves. Part of that is a basic misunderstanding of the way that claims analysis and underwriting really works on the back end. Generally, if you're taking a large self-insured retention or want to take a high deductible that's going to be high enough to impact the rating in the way that you'd like it, there's usually a complex actuarial process that goes on behind the scenes that requires either significant collateral or additional sums that would be escrowed through that process. So again, that's kind of getting into the weeds a little bit. I would say that by and large, a lot of business owners and risk managers probably think they know a little bit more about the game than they do. But that's probably true across any number of items.
Well, right now we're seeing prices go up because of other factors, and I think when you're looking at your prices, when you're looking at the costs involved, add a couple percent so that you can make sure that you're covered better and you don't have that huge outlay because you weren't protected, right? I mean, a little bit more insurance on the front end can save a lot.
Yeah, and I think an important role, as insurance professionals, and as attorneys that are advising our clients on a lot of these issues is, it's relatively easy to identify kind of some of our mainstream exposures. I mean, everybody knows that if you've got autos, you got to have them covered. Or if you've got a bunch of folks out there swinging hammers, we got to have general liability. Really, an important aspect of our roles is to determine, what are some of those items that maybe are not as evident that could really, damage a company or take it down. And so, that's when we're getting into some of these issues related to, cyber insurance, professional insurance. What are the areas on the fringes that may not be top of mind and frankly may not be that expensive to transfer risk, but in the 1 in a million chance that we're unlucky and hit that bad lottery, that we're sure that we're not going to be filing for bankruptcy or in some real trouble. So, like anything else, a lot of times there's a lot of folks that are really good at covering the basics, but when our clients are looking to us, to really give a comprehensive approach, that's where we need to be working with, attorney partners, accountants, HR professionals, to make sure that we really don't have any blind spots that are going to really do damage. Yeah. So, I would say on kind of the pricing front, folks are always kind of interested in various, market climate type items. In general, rate tiers are going up almost across the board. Kind of quick and dirty overview, for folks that may be tuning in here. Some of the coverage we talked about earlier, workers' compensation is generally tied to loss experience within a given state. So in Nebraska, the rates that you pay for your various employee class codes are going to be tied to the loss experience of both your company personally, but also, or your company specifically, and also other companies in that area in the state. And so I say that because in general, most rate tiers in the state of Nebraska, the state rates have gone down in most classes, which means that our loss experience the last couple of years has been better than it has been historically. So overall, that's a good thing. The workers' compensation market continues to be relatively soft, meaning that rates are relatively low and coverage is relatively easy to place for most of our clients, certainly those that have good loss experience and good loss control mechanisms internally. I'd say that market is probably due to harden a bit here. A lot of that, similar to several of our other coverage, is linked directly to the increasing cost of healthcare. So, one of those main components on work comp is we're going to pay for a lot of injuries for our folks. And so the more expensive those services become, that's going to end up getting passed through in the form of rate increases. So similarly, general liability, had been hardening as a market. I think it's stabilized a bit now. So we haven't seen much as far as rate increases that really cause heartburn in that space as much as we maybe did a couple of years ago. But again, the bodily injury component of that is tied, directly to what we're paying in medical on those claims. And frankly, the property side of that equation is also not the easiest any longer either. Increase in material costs, supply chain issues all flow through to property related risks as well there. So I'd say that the two areas that are causing a bit of alarm are auto and excess and umbrella tiers. So auto is kind of the worst of all worlds when it comes to factors that drive that rate. Kind of the three main components there are going to be increased cost of equipment. Vehicles and property cost more now than they ever have. The way they make cars today, I'm going to sound like my grandpa here, but it's not like they used to. So oftentimes auto accidents are leading to larger claim dollars or total losses in a way that we didn't experience before. Second is obviously those medical costs. any injury accident is going to cost more than it used to. And then third is kind of these nuclear verdicts that we're hearing, across several different segments. So, when Werner Trucking gets slapped with a big verdict, or, XYZ Corporation, has a 20, 30, $50 million verdict, a lot of that's being absorbed by the market at large and passed through, to even folks with good loss experience and good controls. So, auto, we're seeing generally between a 5 and 10% increase as a general rule across most portfolios. Again, loss experience and there's some other kind of venue type items that play into some of those rates. But in general, auto's going up, and we hope that some of the items that have caused the increase will be baked in soon, but we're not quite there yet. Umbrella and excess capacity and capabilities have really started to become an issue in a lot of areas. Most of your kind of office exposures and professional service type exposures are not going to see that necessarily as much, although you will see that some office and service carriers that require significant tiers on the excess and umbrella side, whether that be 20, 30, $100 million of extra limits. The limits are harder to come by, and they're getting more expensive. Our umbrella and excess capacity in the marketplace for more high hazard risks is on fire. So, if you've got construction companies, transportation companies, our markets are willing to offer lower limits at a higher price than they used to. And we've got some folks exiting the market altogether. So to tie back to that, the discussion about what's being required in some of these contracts, the days of requiring 10 or $20 million of coverage, because it sounds like a good number as the attorney, those limits are not necessarily attainable in some instances now. And so I would caution, our attorneys that are drafting some of this contract language to not assume that those limits are attainable. And I'd say if you're on the other side of the table, you want to counsel your client to certainly check with their broker and check with their current program before assuming that they're okay to sign. I had a deal that we worked on earlier today where I had a client agreed to provide flood coverage in an area that is literally uninsurable. So, basically they signed a contract assuming that they were agreeing to items that were attainable, and in fact, they are not. So now we're working with, an owner and a bank and all sorts of folks to try to figure out how we're going to remedy the situation, because kind of the sign now figured out later is no longer viable in our space as it maybe used to be in a lot of instances.
No, that's really good. We could probably talk for an hour or more about the flood insurance changes in the market, right? Just on the homeowner policy and how that's all changing. Well, we've gone over, but this has been a master class. Everyone's gonna be happy to watch another 15 minutes of James Boesen talk about this and get an extra 15 minutes of CLE. So that's great. I
might get more takers on audio only.
I'm gonna throw this up for my business law students at Metro as the insurance law chapter too. I'm gonna make sure that they try to watch this too, because man, I took a semester of this in school and I didn't know much of anything before talking to you. So I feel like I've learned something today, and I know the people watching have too. So thank you so much. We'll make sure to have all your information in the materials that come along with this. So if they have any questions, they can reach out to you over email or phone. So
awesome.
Well, thanks everybody for watching. We are doing our little TED style talk with Patrick Ted McNamara. Right?
It's not my middle name.
No? Oh, it's not. Patrick is a solo practitioner who helps small businesses with different issues. And we thought we'd bring him in here today to really talk about how you can counsel your small businesses in contracts that they're dealing with, different things that they need to know about. So Patrick, let me just ask you, first of all, how are you doing?
Good. Thanks for having me today, Dave. Nothing I like more than talking about contracts.
So what are you seeing out there that's something maybe people aren't paying attention to that clients really need to understand about some of these contracts? What's kind of the low-hanging fruit that people need to make sure that they're paying attention to when writing these things up?
So I want to stay away from particular substantive provisions, because obviously they're going to vary so much from contract to contract, and areas of breach. And I really wanted to talk more about issues relating to formation of agreements and execution, and kind of some issues that I end up seeing on the back end where we can't even argue about whether there's a breach because no one can argue on what was the terms of the agreement to begin with. That's a lot of what that's a lot of what I run into.
You're talking about handshake agreements, about email agreements that there was actually not anything, or even just actual.
Well, I mean, I'll get into a few different things, but like, even for example, like a lot of times there'll be like multiple versions of an agreement with different terms floating around. And I want to start first with the fact that you should make sure that when you have a client and you're counseling them on a particular agreement, that the agreement actually gets signed by both of the parties, and that they know what they're signing, and that they're signing the same version. You know, a lot of times we'll have a provision in there that says that an agreement can be signed in separate counterparts, and I do think that's fine, but I think you need to make sure that that you clearly, and I apologize for the dog, like she should be sleeping right now and I don't know why she's not, but you'll say, okay, we want to have this signed in separate counterparts. That's fine, as long as you make it clear that you're signing the same version of an agreement. You don't want one party signing a version that was drafted in June and another party signing a version that was drafted in October, and then fighting about which one should actually control there. So I'm covering a lot here, but make sure the agreements are signed. Make sure that they're clearly labeled. So if you have a version number, I don't usually use like serial numbers on my agreements, but what I'll do is I'll say like, this is a version that was final in December of 2021 or on a particular date, because you'll have effective dates, you'll have a date that it's signed, but we want to make it clear that this is the version that was drafted and finalized on X date, so that there's no issue, because two people could sign two different agreements on the same day, and it'll look like it's the same version, but then there might not be some important provision could be different between the two of them. So you want to make sure that, like, if you're having the parties sign separate counterparts, that they're signing the same version, and make it clearly labeled so that you know that they're signing the same version. And then make sure you get a copy and hold on to a copy.
Right. So like as a footer on the page,
Yep.
have it labeled properly. You know, they have those signature pages that don't have anything else on them. Well, you should have which version this is, so that everybody understands every single page, same identifier, that this is that copy, right? Yeah.
I'll typically put in the footer the name of, and I'll have it on every page, the name of the agreement and the final date of it. That way we know that every page in it is talking about a particular version, and that everyone's on the same page, so to speak.
So you probably have clients that come and say, hey, like I really want to do this agreement, but I don't want the lawyers to get in the way of this good deal, right? Like I just need to get this done. Let's not put too much in there, but you got to cover your bases, right?
Yeah, it comes in. I mean, that conversation I have with almost everyone, and you can play ball and you can have an agreement. In fact, I would encourage you to have agreements that are written in plain English and that are written with short, clear sentences, so that the client can understand what they're signing. Even if they'll tell you they're reading it, they're probably not going to read it. But like, if you at least make it clear to them what it says, and the agreement's written in a way that they can understand what it says, that's going to be very helpful. They're going to be more okay with entering into that. Now, a lot of times it's more difficult and time consuming to write clearly and concisely and shortly. So you need to also try to make, if we're getting into fee agreements later, like make the client understand that if they want a 2-page agreement, that might be more work than a 10-page agreement, to make sure that they're covered. And the other thing is, you can have an agreement that's short that only covers maybe like one particular aspect of the relationship with the parties, so that you say, you know, we're only going to have the agreement control this particular project, or this agreement that we're doing here is only going to control like payment terms and scheduling of payments, but won't get into the nuts and bolts of like installation or the particulars of an agreement. So you can have, you know, agreements that are short and are only to cover a part of the parties' agreements, but you want to make sure that it's clear on the agreement's face that it's only covering a particular area. We talk about like full integration versus partially integrated agreements. One thing I like to say generally is this agreement is fully integrated, so it's covering everything, but it's only covering the topics or matters that are contained within this agreement. So let's say you're leasing some space you have to a tenant, and the lease itself only talks about the lease itself, but maybe you and this tenant also have a deal where you refer business to each other, or there's something else. The agreement is probably going to be silent to that, but you can have the agreement be fully integrated, cover the entire relationship with regard to the lease and all the provisions in the lease. And that doesn't mean that you guys don't have a separate agreement with regard to some other particular area of business, but the agreement that you're signing on that day just controls the relationship with regard to the lease. And you just want to make that clear.
So if there's something we can knock out and agree upon, let's get it down, even if it's not for everything, right?
Yeah, exactly.
Yeah. And that's, I mean, that's important, because certain areas need to be really fleshed out. And if you're not seeing eye to eye on that, the whole thing's going to fall apart. But it doesn't mean that you need to necessarily paper every single little thing, but just the really important parts, right?
Yeah. Getting back to execution and signing everything, because you mentioned earlier, like parties not signing like particular, or we talked about parties not signing particular versions or making sure they're on the same page. And you mentioned like coming to an email agreement. I actually do like when parties use email to come to agreements, because the actual version of the agreement itself is attached to that email. And so you guys, if you both are signing a version that, or you're both responding to an email, yes, I agree to the terms in this particular agreement that was attached to this particular email, that kind of authenticates it itself. And it makes sure it shows that you guys both agreed to the same particular version, because it's attached, it's digitally attached. We can go back and look and see which version was attached. So that actually is a great way to kind of self-authenticate and make sure you're on the same page.
And with digital signature programs out there, you can actually request initials on each page of the agreement, along with signature on the end. So even right there, you know, every single page you're agreeing, this is that page, this is what I agreed to.
Yep.
And another level of, we're both looking at the same thing here.
Right, exactly. I don't use a ton of DocuSign. I probably should. I do like, now I had never heard the phrase before COVID, but everyone throws around the phrase wet signatures now. I had never heard that until like a year ago. It basically just means an actual signature with a pen rather than an e-signature. And I think that was just because like we were differentiating between live actual signatures, in-person signatures, and e-signatures, because we couldn't be near each other. But I do like a wet signature, because the person put their pen to the paper. So you have that level of, you can point to it in court and say, is this your signature? Rather than, no, my name's just typed out in a DocuSign. Right. Or there's a digital version of my signature. And I might be old school with regard to that, but
the digital signature that looks like a preschooler.
Oh yeah, where you type it and it just looks like the script that's hanging up in like a second grade classroom that I never mastered.
So in your experience with the clients that are trying to get deals done, trying to do their work, your job is not only to make sure that these agreements are right, but also that they're following the spirit of the agreement going forward and
Yeah.
not leading to potential rancor down the way, right?
Well, the whole point of these agreements is for the parties to have an agreement on like what their rights and responsibilities to each other. And so I said earlier, our clients don't always read the agreements, but like you do need to make them understand what they're signing, what they're responsible for, what rights they have, and like what could happen if they don't follow the terms, or the other side doesn't follow the term, what their remedy is. So you do have to make sure that the client knows what they're getting into.
Yeah, plan for the worst, hope for the best kind of
Yeah.
thing, right? Yeah.
And like whether that means you have to write an email to them or some other communication to them where you basically regurgitate everything in the agreement. So you write a letter that says you're agreeing to this, 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 and this, even though the agreement itself says this, 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 and this. If you need to take an extra step to make sure they understand what they're getting into, it's good to take that step.
Yeah. In terms of, we've talked about this in the past. I still think it's legit. Is if you're advising businesses and helping them, you should do a checkup. You should do come on in. Let's see where your business is at. Every year or every 2 years, and maybe you haven't talked to me at all, but you got stuff that needs to be looked at. Your business has changed. Your agreements are stale in some ways. They need to be updated. Certainly, maybe different terms need to be added, right?
Yeah, I agree. And if we're just talking about from like a commercial, like attorney marketing perspective, I haven't had luck marketing like a particular product. Like I tried to market like a small business checkup. Nobody seems to really care when I say that. But if I say, hey, I need to take a look at this agreement for you, and just approach it from like, I'm your counsel, I'm just trying to do my job rather than I'm trying to sell you a product. Clients are much more into it.
Yeah.
So if you say like, oh, there's some new particular legislation that just passed and we need to make sure your agreement is in compliance with it, send it to me now and I'll take a look at it. You'll typically get a better response than, hey, we offer this small business checkup service that we can take a look at your agreements.
But then they'll send you the 3 other agreements that they entered into without your consultation. And
yes, of course.
And you'll be like, what the hell is this?
Well, and then you say, hey, I saw what we have here. You guys need to fix this before there's an issue.
Yeah. One thing that we chatted about the other week, and this is about the business relationship between attorneys and their clients, is managing expectations, understanding what the attorney's there to do, what the client expects, what you can provide. And you have a interesting background of practicing in New York and having a little bit more, I think, a good idea on how to manage that expectations and that relationship. Can you talk a bit about that?
Sure. So in New York, along with any written fee agreement, you're required to provide, we always call them attorney bill of rights, client bill of rights. I think they just say a statement of rights and responsibilities, but it basically just goes through, and you can find these if you just Google like New York statement of rights and responsibilities, but it'll go through like, as the client, you have the right to have a zealous advocate. You have the right to have your contacts or correspondence returned in a reasonable amount of time. You have a right to be charged like reasonable fees. And then for the attorney has, or it'll say to the client, the attorney has the attorney doesn't have to call you back in 5 minutes. The attorney doesn't have to discount their rates. The attorney doesn't have to tell you good news no matter what. There's just like it's just a way of explaining to the client additional rights and responsibilities. And even if we're not required to have those in our agreements here, I would incorporate at least some or most of those terms into a particular agreement if we're talking about attorney engagement agreements right now.
Yeah. I think we forget to, in that agreement, really a lot of times we forget to talk about what we're responsible for and not responsible for in a way that protects us from the unreasonable client, from the, the person that's going to say, well, you were supposed to do all this. No, it wasn't in the agreement. And now it's actually explicitly in the agreement that I'm not there to do this, this, and this.
Yeah,
And
it's a great time because it typically kind of the initial communication, the initial written communication with the client. It's a great time to manage expectations. And if you have a thorough written agreement, it shows that you have a thorough work product too. So you're demonstrating your value to the client right from the start. So I think it is good to set expectations, both of like what the client can expect from you and what you expect from the client. I think that's going to provide a lot of value down the road. You don't want to be having to point to your agreement with the client on a regular basis, because usually that means you're in some dispute, but it's nice to have it if it's there.
well, and again, I've said this many, many times, but you talk about value, and I think there's no reason that this agreement, first of all, has to be a page long, 2 pages long, whatever. But in there, talking about the value of your service and how what you're doing will, potentially save them costs for litigation down the way. The value of this is can be quantified in these ways and other ways. So when
Sure.
they're looking at, it's a $250 an hour rate, what am I getting out of that? Or if it's a flat fee, what am I getting out of that? You're getting the value of, and some attorneys will say this, this is my years of service, this is my education, this is, all the hundreds of clients that I've had, they even put that in there to say the value you're getting is cumulative, and it can be preventing litigation down the way too. So, spending a little bit more to do this agreement could hopefully save a lot of money down the way.
Well, I think kind of what you're talking about is carefully defining scope in an agreement, to make sure that, because like I've seen a lot of attorney agreements, it'll just say like providing commercial services or something. And you're not making it clear to the client what you've been hired to do. The client hasn't made it clear, or at least in writing hasn't made it clear, that of what exactly you need to provide to them. And so months down the road, there's no way to point back and say, hey, I did what I was supposed to. Or the client can say, no, you didn't do what you were supposed to. So I do think it's important. I think we have an obligation to clearly define scope in the agreement. And that also just like connects to fees, because like your fees are going to be related to the scope and how you define your fees. So by carefully defining the scope, you can also make your fees. I think that's the only way to make your fees, show that your fees are reasonable, if you have a carefully defined scope. Now, I will say, typically, like I'll get hired for one particular project from a client, and we'll define the scope. But generally, like if they're happy with my work, they're going to have me do new work down the road. And we're generally not entering into a new particular agreement. Like we'll have a correspondence with each other that says, hey, handle this new project for me. And I'll say, okay, sure. And I might say, it might take X number of hours, but I would have in the agreement, like contemplate that there's going to be outside the scope work, and say it's going to be under a different rate, or it's going to be under the same rate. But just make it address the fact that like, yes, we have a clearly defined scope, but like we should contemplate also that like there's might be other work down the road, and make sure the agreement at least addresses that and makes it clear either how it'll be handled or how you'll plan on discussing it in the future. I just wouldn't just leave it generally open-ended. You want to always be talking about scope with the client. So even when the scope may change, but it's going to be through your correspondence. So a client will say, hey, go file this lien for me or something. And you need to make sure you're on the same page with the client, because that's a new scope then. And even if it wasn't in the original agreement, you want to always just make sure you're on the same page with the client. And speaking of being with the client, you want to also clearly define who the client is. So if somebody who owns a business comes in, are you representing that individual? Are you representing the company that that person is coming in as. And if you are representing a particular company, let that person know, I have the company's interests in mind. Like, there's a chance that your interests may diverge from that, and at some point that may create a conflict, and just be aware of that. And I think it's important to sniff out potential conflicts and address them right away, because most conflicts are waivable, or at least conflicts with regard to like business entities and partners and everything like that. As long as the client understands like the nature of the relationship between you and the client. So between you and the business, or you and the client individually, and they say, yes, I understand that. I also understand that there could be a potential conflict, and I'm willing to still move forward anyway. I think it's important to at least address that, get the client's informed consent, and make sure that there's that if there is a conflict, that the conflict's been waived, and that they've been informed of the potential conflict. And then just always kind of always be aware that there may be a conflict that comes up down the road, that you need to go back to the client again and say, hey, this is diverging from what we originally talked about. You don't seem like you're really on the same page as the company right now, or as your partners. And so like, we need to readdress this and talk about it again, either with you and your partners, or just address it at the time for whatever particular situation comes up.
Yeah, no, that's a good point. Certainly can get some different interests down the way on businesses, and this is a principle in the business, but maybe not the ownership of the business, and things like that. We got about 90 seconds left. From your perspective on helping these businesses, what is the scene out there right now? Is it good? Are we getting we coming back to normal in terms of,
I never felt like I never felt like my clients really stopped. Maybe there was a few weeks last year where nobody knew what was going to happen until we kind of settled in. But there never felt like a time where anyone was going to be stopping doing business. Maybe the nature of the businesses people were entering into were different, and maybe people changed some of their plans, but people seem to be pretty enterprising. They were enterprising, and they're enterprising still. And so
there's a way to make money, right?
Yeah. And the non-lawyers seem to have figured that out.
There's a price on everything. You just got to change it a little bit to make sense. If storage or if containers on ships are going up 200%, then got to adjust your prices a little bit, but keep on doing it. So I just like to think that there's always money to be made. There's always business opportunities out there, and I think even more so now than before. So
yep. Yeah. Oh, one last thing, getting back to, we talked about carefully defining versions of agreements and making sure everyone signed that goes for addendums too. So if you say, pursuant to this agreement, we're going to agree to some like compensation plan that is in another document, make sure the agreement like specifically shows which one you're talking about, and make sure that the addendum or the schedule or whatever also is specifically defined, so that there's no confusion as to like which exhibit or addendum or schedule the agreement's referring to.
Is it an okay practice to even number every single paragraph, or does that just get outrageous at some point?
Well, that's not going to really do anything, because like you could have two separate documents with 10 paragraphs.
Yeah.
You want to make sure that like you've named the document, and that you refer to it kind of throughout. I was going to talk about other stuff like recitals and stuff like that, but I think we're good.
I don't want to hear about what your kid's already playing on the piano, man. Oh wait.
That's his mom. His mom plays to him like every night.
So
he likes whistling. He likes whistling a lot. Goes nuts for whistling. And I'm a better whistler than a piano player.
Well, thank you for joining us today to do this TED Talk. If anybody has any questions, we'll have your email up. But appreciate it. And also try to find the New York Bill of Rights for attorneys and for their clients and put that in there as well. So I think this is a good talk. Thank you so much. And we'll move on to the next person in line.
Thanks for having me, Dave.
Talk.
Hi, I'm Meagan Mosslander with Legal Aid of Nebraska.
And I'm Emily Sands, and I'm with Legal Aid of Nebraska. Hey, Meagan, did you know that Legal Aid of Nebraska uses volunteer attorneys all the time? You don't even need to be experienced in the type of law that we're seeking. Like, you don't need to be a housing expert to help at eviction court.
Wait, you're telling me that my attorney friends can help someone possibly stay in their home without knowing housing law? I suppose you need to volunteer and like learn all this stuff for 20 hours a month or something like that. I can tell you my friends generally don't have that much time because they have families and dogs and other time commitments. And they always talk about this thing that attorneys have to do called billable hours. They work a lot.
At Legal Aid of Nebraska, we understand. So the time commitment to help legal aid can be pretty minimal. We want to make your volunteer experience work for the busy schedules that we know our volunteers have. We're just really grateful that they want to help us. The time that each volunteer attorney gives provides legal aid with the opportunity to help more people who can't afford an attorney.
Well, we do get over 1,400 calls or emails for assistance per month. So we could really use the extra help. Sometimes I don't even know if attorneys throughout Nebraska know all the work that legal aid does and how we help low-income Nebraskans.
Maybe you should tell them. I know you have that speech down pretty good.
Well, that is true because that is what I get to do. As the Chief of Development and External Relations, I get to tell a lot of people about the work that we do, and I love it. So just a little blip. We're a statewide organization with offices in 7 cities. We help low-income Nebraskans address their civil legal needs in 4 key priority areas: housing, as we mentioned, children and families, debt and finance, and income and benefits. So this means that we help everything from foreclosures and evictions to domestic violence, family law issues, garnishment and medical debt, and to helping people with public assistance benefits. Legal aid is a resource for thousands of Nebraskans every single month. Every single year. Last year alone, we helped over 12,000 people, and we're on target to help more than that this year. So we could really use volunteers as much as possible. Now, let's talk about ways that people can volunteer, because I know there's several.
Yes, we do have a lot of ways that people can volunteer. So first of all, at our clinics, attorneys can spend anywhere from 1 to 3 hours helping clients resolve a legal issue. We have at least 1 clinic a month, so you can pick and choose how often you volunteer, whether that is once a month, twice a month, or even just twice a year. We appreciate any help that you're willing to give.
When are these clinics held? My friend's schedule is booked out for months in advance. And what if my lawyer friends don't have time to leave their office? Sometimes they won't even meet me for lunch or dinner.
Well, some of our clinics are after work hours during the week, like 5 to 7 p.m. So if weekdays work better for you, you can work that into your schedule. And some of our clinics are on Saturday mornings for those who have busy weekdays. And for those who don't have time to leave the office, we also have virtual clinics.
Like, you mean on Zoom?
Well, Legal Aid of Nebraska actually has its own virtual platform for pro bono clinics. It's called Legal Aid Connect, and it allows volunteer attorneys to help clients from anywhere, their home or their office. It's a great way to sneak in pro bono when you don't have time to leave the office, and you still want to get a meaningful volunteer experience meeting with a client one-on-one. With Legal Aid Connect, you can connect with the client via virtual chat. So you and the client see each other and you can draft documents there.
Virtual pro bono sounds like a really great option since Nebraska is really big. But so does helping clients in person, because then at least you get to meet them, kind of get that vibe, because we're all really over the Zoom stuff. But it does really give us the option if somebody's living in Western Nebraska, an Omaha attorney could help them, or vice versa. So more Nebraskans can get helped despite the distance.
Right.
So can you tell me a little bit, do attorneys have to go to court? Because that seems more time consuming.
No, not all of our clinic, or none of our clinics require attorneys to help the client after the clinic. All of our clinics are what we call assisted pro se, or brief service. So the volunteer helps at the clinic and then their work is done.
That sounds like a really quick, no strings attached way to help low-income Nebraskans try to overcome some legal barriers.
Yes, and we have several clinics. So I'll tell you about a few that attorneys can get involved in 2022. So we have a record sealing and set aside clinic, and attorneys there can help our clients remove barriers to unemployment. At this clinic, they prepare petitions to set aside and record sealing documents.
What is a set aside and how does that help somebody?
So a set aside is an order by the judge which voids a person's criminal conviction. As part of the decision to set aside a criminal conviction, a judge must believe that it's in their best interest to do so, and that setting aside the criminal conviction is consistent with the public welfare. The decision is discretionary, which means it's completely decided by the judge. The set aside, however, does not erase a criminal record because in Nebraska, we do not have expungements. The order setting aside the conviction, however, is added to the criminal record. For our clients who apply to the record sealing and set aside clinic, many are trying to get a job, and that criminal conviction is standing in their way. When they successfully get a criminal conviction set aside, a potential employer doing a criminal background check will see the conviction and the order which sets aside that conviction.
Wow. Do volunteer attorneys have to do anything else at these clinics? I mean, they sound really impactful for our clients.
Yes, along with helping clients set aside criminal convictions, they may also prepare record sealing documents. A person is eligible for record sealing if criminal charges were filed and brought, but those charges were dismissed. If that is the case, those charges can still be damaging to someone's record, especially if they're trying to get a job or housing. When a record is sealed, it is removed from the public record, meaning that a potential employer or landlord will not see it.
Well, that sounds so helpful. I mean, if we can help someone get a job or find a safe home to live in, that's life-changing and can really push someone to the next level and out of poverty.
That's true.
But my question is, so I have a friend, an attorney who works in corporate law, and they don't do criminal law, and they've never done anything with criminal law. So how would they even know where to begin at this clinic?
Well, for all of our clinics, we send volunteer attorneys a training video to watch. So that training video includes all the information the attorney needs to prepare them for the clinic. And we also send attorneys forms that they will use to draft at the clinic. So everything that they need to help clients is provided to them in that email. And if they still have questions, I'm only an email or a phone call away from answering any of those questions to make sure that our volunteers feel prepared to assist clients on the day of the clinic.
So an attorney that's going to help at this type of clinic or any of our clinics, they get to volunteer, they get some free training, and there's people there to help them. So they don't have to be worried about messing up.
That's right.
That sounds kind of like a good deal. I mean, you get to maybe learn something new and help people at the same time.
Yes.
That's some time well spent. Can you tell us about any other clinics? Because I know that that's not the only one that we do.
Right. So we have several others. Attorneys can also volunteer their time to assist clients with gender affirming name changes at our LGBTQ name change project clinic. So we offer that clinic virtually and in person. And in 2022, attorneys will have at least one chance to get involved with that. During that clinic, attorneys prepare name change documents and provide advice to counsel clients through the rest of the process so they can complete their name change successfully. And this is really helpful for our clients because getting a name change is a meaningful process in itself. But we also, in some instances, are able to cover filing fees for clients.
Right. So that's the clinic that you talked to me about trying to raise additional funds to cover some of those fees because they can be really cost prohibitive when someone's trying to transition and really find they're happy.
Right. With a name change, when you're filing for a name change, a client, you're not allowed to get your fees waived. So a client cannot apply for an infirm pauperis application with a name change, and the filing fees are quite expensive for a low-income client. So being able to apply for this clinic and get their fees waived is a huge part of the experience for them.
That's really amazing. So let me get this straight. We have a client, they come and can get their name changed while, during their transition process. I have to raise some money to cover those fees, but then someone can come and volunteer their time, and that can just change someone's life.
Yes, and it has for many of our clients. It's a really meaningful experience for the client and for the volunteer.
So you have another clinic though. I mean, you gave it some weird name, like, wasn't it like a man's name or something?
Transfer on death deed.
Oh,
Sometimes
wait,
referred
that's
to
the
as-
Todd.
Yeah. So we have a transfer on death deed clinic that we'll also be offering in 2022.
So tell me a little bit about Todd.
So a transfer on death deed, often abbreviated TODD or TOD, is a document that allows a homeowner to transfer their property without the expense and hassle of the probate process. For many low-income families, their home is their most valuable asset. A transfer on death deed allows the homeowner to transfer the home to another family member or an adult beneficiary that they elect. This allows the home to stay in their family. And as a result, it builds intergenerational wealth for those who have been historically unable to do so. In 2021, Legal Aid of Nebraska held the first clinic of this kind to help clients who have received their home from Habitat for Humanity complete the entire TODD process required. So volunteer attorneys drafted the transfer on death deed for clients at the clinic, and Habitat for Humanity filed them with the Register of Deeds.
That's really cool. I mean, we really want to try to brighten and make North Omaha better. And what's better than keeping those homes in the North Omaha area in the family?
Right.
Well, so can you tell me like how many people did this clinic help? Like, what can people expect when they walk in to volunteer?
So at this clinic that we held in person at Habitat for Humanity, we helped around 37 clients overall. And we will be holding this clinic again this year. And the goal is to help 50 clients. So we can use the help of several volunteers, and we would like to have that clinic twice. So if you're interested in that opportunity, you'll likely have at least one opportunity to participate.
Oh, and that was the clinic that you said, can you pick up some bagels and juice? So you come, you feel good, you get to meet cool people, you get to hang out with legal aid folks, and you get some bagels and juice.
Yes, it's a good time.
It is a great time. And sometimes we have fun legal aid swag.
We do.
So again, my friend, I have an attorney who's a friend who's an attorney, and they do family law. My friends never mentioned Todd to me. So can they help?
Yes, actually, most of the attorneys who volunteered at the Transfer on Death Deed Clinic this year don't practice probate law, and they probably hadn't prepared a transfer on death deed or been all too familiar with it. They watched the training video that we provided to them, and then they used the forms that we also provided, and they did a great job helping clients.
And I met that one attorney, and she was new, and she said how meaningful it was for her because she not only got to help clients, but she got to learn something new that she could take back to her own practice. So that's really beneficial as well.
Yes, it's a great way to ease into a new practice area or learn something new that you may have not otherwise learned at your firm or on your own.
So we have 3 clinic opportunities that attorneys can volunteer at: the set aside, the name change, and the transfer on death deed clinic. I know that we also, and it's been in the news a lot, the tenant assistance project, and that's where people can volunteer to help people stay in their homes, basically at eviction court in both Douglas and Lancaster County. But we have other clinics too, right?
Right.
Can you tell us a little bit about those?
Legal Aid does hold other clinics. We have a monthly virtual pro se divorce clinic. So that clinic helps clients who are from rural parts of Nebraska to get a pro se divorce and complete that process. And the attorney drafts the forms and helps them through the process on a self-represented basis. So the attorney does not have to appear in court with that. And it's virtual. So it helps clients in rural Nebraska, and attorneys practicing from anywhere can help them.
That also seems to save people a lot of money, because my friends who've been divorced say, ooh, that costs some money.
Yes, it's great for clients who are seeking a pro se divorce. And we're always scheming up new clinics to offer to our clients. So if you want to stay tuned and up to date on our clinic opportunities, or you're interested in any of these that we mentioned, you can email probono@legalaidofnebraska.org and let us know that you would like to get regular updates on this or be notified when a clinic is coming up.
They could also follow us on social media because sometimes we do talk about when we need volunteers on there as well.
Yes, our social media is a great thing to follow as well. And you can visit our website, go to our legalaidofnebraska.org website /get involved.
So I know that clinics aren't really the only way that attorneys can help, right? I mean, there's so many Nebraskans that need our help, and the justice gap just keeps growing. Before the pandemic, it was huge, and we know that it continues to grow. So can you talk a little bit about what other ways that attorneys can get involved at legal aid?
Yeah, that's true. So attorneys seeking to help clients beyond assisted pro se service is by providing our clients legal assistance through a more traditional one-on-one client representation. So for some cases, legal aid pays attorneys to provide representation at a reduced rate. And in other instances, attorneys provide assistance on a pro bono case placement basis.
So attorneys actually get paid?
Yes. Legal Aid of Nebraska will pay attorneys through our reduced fee program at a reduced rate, and they hire and pay attorneys a contract rate of $90 per hour to represent low-income clients of Legal Aid of Nebraska.
How does how does an attorney get these cases, and what kind of cases are they? I mean, I know they have to fall in our priority areas, but can you tell me a little bit more about the cases? You know, I'm not an attorney.
Yes, so cases for the reduced fee program are usually family law matters, helping a client who is in an abusive situation with a case that will help them achieve safety. That may be representation at a protection order hearing or with a divorce or a custody case.
I can't imagine, that would be really life-changing for that family. But what if an attorney doesn't want to take an entire case? Because I've heard that family law cases can take a long time, but they want to do other pro bono work outside of helping at the clinics.
Yeah, we have a pro bono case placement option. So legal aid matches clients with private attorneys who may give the client legal advice only, such as perhaps drafting court documents or a letter on the client's behalf, or may even attend a hearing with the client. It may be something more akin to limited scope representation. It just depends on the client's situation and the attorney's willingness to assist. Typically, for case placement, pro bono attorneys will help with simple wills and powers of attorney and other matters that are not complex, and where the assistance should be possible without a substantial commitment of time.
Well, that makes a lot of sense. And I also would think for an attorney, those would be pretty simple things. But for one of our clients who are really struggling to get by, that could be something that just gives them really that step up into more economic freedom, more happiness, really on a path for self-sufficiency. Because the clients that I've talked to, their legal issues are huge burdens on their life and affect everything from their job to their home to their emotional well-being.
Yes, regardless of whether an attorney is taking a family law case or helping draft a letter to a landlord or to seek the return of his security deposit, the help is greatly needed. And for the client, it makes a tremendous and positive difference. So can I tell you about a couple of other examples that we have, stories from clients that might illustrate how attorneys have helped?
You know, I love client stories and I love to tell client stories. So please tell me.
Okay, so we have many stories, but as one example, I'll tell you about our client, Mary. Mary came to legal aid for help with a divorce from her husband who had been physically abusive to her, their children, and the family pet for years. Mary worked in the healthcare industry, but she was only making $1,400 per month, meaning that there was no way she could afford a lawyer. She was struggling to keep bills paid and take care of their 5 kids without any financial support from her husband, who was earning nearly $80,000 per year and who had left the family home, leaving them without any help. But it was when he hired an attorney and filed for divorce, seeking custody of the children, that she knew she needed help. So she turned to Legal Aid of Nebraska, and Legal Aid of Nebraska handled the case for her, and she was able to get the assistance she needed.
Which is really huge. I'm so glad that I wish more people knew about legal aid, and I'm so glad that people feel that they have someplace to turn. And we can hopefully help them and provide what they need, but we absolutely cannot do it without volunteers. I mean, 1,400 calls for assistance a month. We don't have nearly as many attorneys as we possibly could, so we could serve more Nebraskans.
Right. So I'll share an example of how someone could help with pro bono case placement, a story about someone named Robert. Robert was living in Western Nebraska. At age 77, he contacted legal aid asking if we could help him with a last will, transfer on death deed, and a power of attorney.
There's that Todd again.
Yes. His wife had recently passed away, and he felt that he needed to be prepared. His only asset was his home, and he wanted it to transfer upon his death to his beneficiary without the need for the expense of probate. So like Mary, his attorney's fees would have been a financial hardship, and his only income was Social Security. So he had nowhere else to turn for an attorney to get that help. But Legal Aid of Nebraska, through pro bono case placement, was able to help him get those documents drafted. And those are things that we can't do without the help of the private bar helping support our clients.
And we helped Robert and his beneficiary, because then his beneficiary wouldn't have to, the beneficiary would be grieving Robert's death when something happened to Robert, and this makes it a smoother transition, it seems like.
Yes, I mean, the impact of our pro bono volunteers is huge. And those are just a couple of examples of people who both needed a lawyer but never could have afforded it without the generosity of private attorneys who've been willing to give their time to legal aid clients.
I know sometimes we hear like legal aid is, a law firm. Don't they have enough attorneys? We do have a lot of attorneys, but they can't help everyone.
Right. As you know, the need across the state is so much greater than Legal Aid of Nebraska's resources can stretch. We don't have enough attorneys to resolve all the legal issues across the state. And the only way we're going to be able to help is with the assistance of a non-legal aid lawyer to help us fill in some of those gaps. And that's where legal aid's reduced fee and pro bono case placement programs have been key, and where attorneys from every type of practice can make all the difference.
And learn.
Yes.
For, as you said, like maybe 2 or 3 hours, once a year, once a month.
Yes. So attorneys who are interested in participating in any of these opportunities, including the reduced fee, the pro bono placement, and the clinics, can contact pro bono at legalaidofnebraska.org or follow us on social media if you'd like to just stay in touch with our general schedule. But if you'd like to be updated on our upcoming calendar of events, please reach out to that email address. It's pro bono at legalaidofnebraska.org. And we will make sure to update you on all of our upcoming opportunities, or let us know what specifically you're interested in and the time commitment that you're willing to give, and we will make it work for you.
And that's the thing. We really try to be flexible because we know everybody's life and time commitments are very different. So we're just really grateful if you can give 1 hour, 2 hours, 3 hours. I know at that one clinic I stopped by, the person had to leave a little bit early, and you were like, okay, that's all right. Like, we understand.
Yes. We appreciate any help that we can get.
And we provide the training. So you don't need to be fearful that that's not an area of law that you practice.
Right.
So we hope that you will consider, after listening and watching us, helping Legal Aid of Nebraska and low-income Nebraskans across the state receive the equal justice that they so rightfully deserve.
Thank you.
Hello, I'm Meagan Spomer. I'm a managing attorney here at Nebraska Legal Group. I'm here today to share with you 4 things everyone should know about practicing family law. As a top level overview, the things I'll be talking about today are: number 1, don't be ruled by your emotions. Number 2, see the forest for the trees. Number 3, don't bury the lead. And number 4, understand your audience. So to get started, let's talk about not being ruled by our emotions, because I think that's probably one of the most important things we can do in this practice area. Not only is it easy to get drawn into your clients' emotional issues, I think it's easy to let that spill over into your own personal life and practice. Family law is a particularly emotional area of the law. It's not like doing tax work for a corporation or creating and ending businesses, which I think can have their drama at times too. But in family law, you're dealing with some of the most important things in a person's life. Their children, their income, and all of their finances, all of their money, everything that they've worked for. And as far as they're concerned, it feels like it's all crumbling around them. And when they feel like that, they tend to behave in ways that they wouldn't normally. Now, it's our job as their attorney to remain as objective as possible and make sure that we receive and hear them for what they're going through, but also guide them to a place where they can make rational decisions. If you can't do that, they're going to end up making choices that harm themselves financially and personally in the long run. I think we all know the example of those temporary hearings where people write down some of the most awful things you've ever read about this person they've been married to sometimes for 10, 15, 20 years. Those things can't be taken back, and they will permanently alter the parenting relationship between those parties. So if we can help them understand that from the beginning and reduce some of the emotional anxiety that they're experiencing in the process, we can really do a lot for our clients in making sure that they reach an optimum outcome. It's the little decisions that we make along the way, often very rooted in emotion, that affect the ultimate outcome of the case. And so if we can keep focused on rational thinking and help them separate their emotions from reality, we can do a much better job for our clients in making sure that they make those good decisions. Number 2, see the forest for the trees. This is kind of an extension of number 1, which is don't be ruled by your emotions. At the end of the day, it doesn't matter if we're in a spat with opposing counsel. It doesn't matter if our clients are angry at us for whatever advice we've given them. What's important is that we've given that advice and we've done it in a way that helps them focus on the long-term outcomes and not on the short-term gains, whatever they may be. One thing we can get caught up in as attorneys is the interpersonal nature of the opposing counsel relationship. If you can keep focused on your client's best interests and not take personally what's going on between you and opposing counsel, I think that also translates to a much better client experience. Our personal drama with whoever we're practicing with should not ever overshadow the advice we're giving our clients. And if we can't see that forest for the trees, then we're going to end up giving advice to our clients that leads them down a path that isn't in their best interest. Same thing as when we're letting them be ruled by their emotions. We can't be ruled by our own emotions. There's a big picture at the end of every case, and that's making sure that our clients are in a position to co-parent for the long term, or if there's no children involved, to be able to move forward from the experience in as emotionally healthy way as possible. That requires us to set aside whatever's going on in our lives, personally or professionally, to make sure that they have all of the information they need in order to make the best possible decision for them in their case. When we take our cases to the court, it's important that we put only the most important and pertinent information before the judge. The judge is going to make a decision based on a very limited set of facts. They're going to see such a small sliver of who your client is and what the facts are, and they have to make a very big decision that's potentially going to set the status quo. I'm thinking specifically in the context of a temporary order. So this leads me to number 3, don't bury the lead. We have to be really efficient with the court's time, not only because they have so many cases, but because they're humans and they're only capable of absorbing so much information in order to make a very big decision about what's going to happen with your client's money, time, and children. When I advise my clients on a temporary order, I try and keep their attention as focused as possible on the facts the court has to consider. This means, what are their job schedules? What are their incomes? We make sure and attach all the relevant information like pay stubs or tax returns if necessary. We describe in detail the sort of interactions your client is having with the minor children and with the other parent. And we also try to foresee what that situation will look like once they're no longer living together, if they are currently still living together, because usually that's one of the purposes of a temporary hearing, is to decide who's going to move out of the marital home. With respect to that information, less is more. If we can be as direct and to the point as possible, the judge has much less noise to sift through and can make a decision based on pertinent facts and not a whole lot of static, frankly. This isn't always easy. When allegations are made against your client, you have to respond. Ignoring them, I think, doesn't ever help the situation. Also, if you can keep the judge focused on information from parties that's actually valuable to them, you know, they're not necessarily interested on what each party's mother thinks of them, because everyone thinks they raised the sweetest boy in the whole world and they could never possibly do anything wrong. However, if you have, you know, a sibling or a friend or a coworker or somebody that's got firsthand knowledge of the things that are being discussed, those are oftentimes much more valuable to the judge because that person has less skin in the game. They don't really have much of an interest in lying to the court. And if they're willing to write an affidavit, it's usually because they have the best interests of the children in mind when they do so. And finally, it's so important to understand your audience, getting to know your judges, getting to know your bailiffs, getting to know all of the people that are going to be players in your case, whether it be a guardian ad litem, a therapist, you know, anybody who has any sort of decision-making power. It's so important to know them, what motivates them, and the things that they tend to look for in cases. You know, if you know your judge cares a lot about substance abuse, and that's an issue in your case, that's something you're going to want to play up, unless it's going to hurt you, in which case that's something you're really going to want to play down. However, if you know that judge doesn't really take, you know, the occasional, you know, weed ingestion all that seriously, or not cut that. If you know your judge doesn't care too much about the occasional use of marijuana or something like that, you know, it's not going to help your client to waste their time talking endlessly about, you know, how every other weekend or so opposing party on their own time likes to, you know, sit and smoke a joint. It's just not going to be important to that judge. And so knowing what motivates your judge is just so incredibly important to getting the best possible outcome for your client. This can be difficult in areas that you don't practice that often, in which case I strongly advise you either pick up the phone or send an email to someone in the area you know who can kind of give you an idea of what is and isn't important to that judge. In my experience, experienced attorneys are often very welcoming of those sorts of communications. I think they like to have outside attorneys reach out to them and kind of feel out their jurisdictions instead of coming in thinking they know everything and, you know, frankly, making a fool of themselves in front of that judge, making a big issue of something everyone else in the room knows isn't important to that judge. So doing what you can to learn that information is hugely important, and I strongly encourage it. And while I know that this was very brief and high level, I hope if anyone has any questions or suggestions that you'll reach out to me and let me know. Otherwise, happy holidays and take care.
Hello, my name is Mark Jacobs. I'm with the firm of Bressman, Hoffman, and Jacobs, a 2005 Creighton graduate. I sit as the chair of the OBA Lawyer Referral Service Committee. And today we are going to cover two topics, mainly the topic of public accommodation under the ADA. And then if we have time, we will touch on negligent referral. We have 20 minutes and I'll try to get through this as efficiently as possible. Please note that this is an overview of these two topics, and I encourage you to look into these topics in more depth for your firm, whether it be a large firm, medium, or solo practitioner. Starting first with public accommodation, we're going to get into how this affects the operations of your firm, what you need to look out for, what duties you have. But let's start with generally the law. The Americans with Disabilities Act is a federal civil rights law passed in 1990. This law prohibits the discrimination against individuals with disabilities and seeks to have them be awarded equal access to all rights under law, and for our purposes, the legal services that they may be seeking from your firm. This is found specifically, public accommodation is found in Title III of the ADA, and 28 CFR 36 is where you'll find the regulations, definitions, design standards, implementing what is set forth under the ADA. Again, what we're looking at today is the prohibition against discrimination against disabled individuals by places of public accommodation. A couple definitions: disability means a physical or mental impairment that substantially limits one or more major life activities of an individual. Now that's sort of a sliding scale on that, but as the guidelines state, someone with a minor pollen allergy would not come under this definition of disability. And then public accommodation. These are places the public can enter, and specifically under subparagraph F of Title III, it reads, quote, an office of accountant or lawyer, unquote. So there's no question that your firm comes under these regulations. And don't think that, okay, I rent, so for the physical barriers and the design guidelines that are put forth here, that I can get out of any duties under that. No, the ADA and public accommodation rules apply to tenants and landlords. So, if there is something, about the physical structure that you're in, good idea, and you're concerned that it's a restriction on someone with a disability, good idea to approach your landlord on that and make sure that is addressed. So let's talk about general duties. And as we're talking physical barriers, we have a duty to remove any physical barriers that would restrict access to your services by someone with a disability. In your standard, I understand that's the first question that was raised when we brought this topic for a CLE about 8 years ago is, well, I'm a small firm, we don't have a lot of money to apply to this. The guidelines say, is it readily achievable without much difficulty or expense? Now this implementation of or removal of the physical barriers to access your services, there's a hierarchy of what items in your building you should address first. There's the making sure you have an accessible approach and entrance. Then it's the access to yourself, the services you're providing. Then you move on to restrooms, and then to any other measures necessary. I would direct you to look up the ADA accessibility guidelines and the ADA standards for accessible design, both found on ada.gov. And really what it comes down to, we talked about undue burden or much difficulty or expense. It's a balancing of cost and practicability. And so you have to know, okay, with a firm of my size and with the income we bring in, would it be too much of a cost for us to bear to make certain changes? I will say, if your facility was built after 1991 or already you made renovations to come into compliance with the ADA, then you are grandfathered in for the regulations that were passed in 2010 that updated the guidelines on design. Also, I want to note that if you do make a change as to one aspect, say you make a change on your parking, if you make one change to come into compliance with the guidelines, then you have to go all the way with making sure you're in compliance with the guidelines as to your parking lot. Also, this is a continued responsibility. So if this year it would not be, practical, cost-wise to implement any changes, but in 2 years or 5 years down the line, your earnings are higher and you are able to afford it at that time, then you must make the changes. The second major duty, aside from making physical changes, is a reasonable modification of your rules and procedures. Number one, you cannot have any criteria that screen out individuals with disabilities. Example, you can't have a policy saying no service animals. You must have an effective means, you must provide an effective means of communication. This means you must provide aids, again, unless there's an undue burden or it fundamentally alters the services you're offered. If you can, provide this aid for communication without significant difficulty or expense, then you are required to do so. Common examples are for hearing loss, and the aids would be an ASL interpreter, video relay system, text talk system, using the CART system, which is communication access real-time translation. All of these are examples of aids you would have to provide. Some instances, maybe you'll be able to get by pen and paper, but considering the complexity of the work that we do in the legal field, that normally isn't going to fly all the time. If you're having a person with vision disability, it's providing braille materials, large print materials, audio recording. Again, reading an email or a document or another communication to the client would suffice in certain circumstances, but again, dealing with complex issues, you should not leave it to that. And also a tip is ask the client what they prefer, but always understand that the duty falls on you, the burden falls on you as the provider of the legal service. What happens if you violate any of the regulations? Well, there are what they call drive-by litigation, where attorneys will go by with clients in certain neighborhoods, look for these violations, and then start filing suit. So private lawsuits against you are an option, where the individual can seek injunctive relief. They can be awarded attorney fees and litigation expenses. Now, a suit by the government is also a possibility. Under those types of action, they can seek equitable relief, monetary damages. There's also civil penalties. If it's a first offense, a civil penalty can be up to just over $96,000. If it's a second offense, the civil penalty can be up to $192,000. And now add on to that, attorney fees and litigation expenses. Some case examples we have from the DOJ. Most of these were resolutions with the government through agreement. And as you'll see, a lot of these have to deal with someone with hearing or vision impairment. The Tyrone case out of New York, the attorney failed to provide an interpreter for a deaf client, instead relied on the client's relative for that, ended up having to pay $2,200 to the client and waive any of fees owed from the client. Then they are basically under review for 3 years. The Cohen case, again, another person failed to use an interpreter for a deaf client, used the client's mother, had to pay the client $7,000. Had to post in their office their new procedures, and were under review from the government for 2 years to make sure that they were properly implementing policies. Delaware case, Hearn Law Office again failed to provide ASL interpreter. They didn't have to pay any fees, but had to post a policy on their new procedures in their office, and they were under government review for 3 years. Perutka out of Maryland from 2013. This debt collection firm, they refused to accept video relay service calls. They had to pay $30,000 to the complainants, and they were under review for 3 years. And you can look as nearby as Creighton University. If you recall the medical students from about 8 years ago, the university failed to provide interpreter services for him. He had a hearing impairment, and he paid for the services himself. And the jury ruled that the Creighton did discriminate, but they did not order fees in that matter. They found that it was not an undue burden for the university to file to provide interpreter services for the medical student. And the cases go on. There's a Colorado case from 2010 where the law office did not let a service animal from opposing party be present at deposition. $30,000 to the complainant, $10,000 to the complainant's husband, $10,000 for a civil penalty, 3 years of review. Now, as to service animals, basically 2 exceptions for that. Unless the animal cannot be brought under control, is uncontrollable and can't be brought under control by the owner, then you can exclude the animal. Or if the animal is not housebroken, then you can exclude the animal. Also note, this does not apply to, this is service animals only. It does not apply to emotional support animals or anything along those lines. So some best practices, inform yourself, train your staff. Number 1, go through the guidelines. There are many helpful, short, easily, digestible guidelines there on the ada.gov website. Review those. There's a guide for small businesses. There's separate guides for service animals, for parking, for mobility devices, and how to accommodate those. Okay. Don't ask a client to bring a relative or somebody else to interpret. Make sure that you are providing that service. Never bill your client for the cost of the accommodation or the aid that you are providing. As I stated earlier, ask the client, what do they prefer? Use the ADA checklist to make sure that your physical office is in compliance with the regulations. And then if you cannot, if your physical location, you can't make it to accommodate the individual, the client, consider meeting with the individual at another location. Simple solutions like that could go a long way to avoid any litigation or government oversight. Again, please go to the ada.gov, use those guidelines, use those checklists, and make sure that your office is in compliance physically and with procedures. The second topic that I wanted to cover today is negligent referral. We went over this again about 8 years ago, and I'll start off by saying that negligent referral, there's no case history in Nebraska. It hasn't been recognized as a cause of action, nor has it been recognized in Iowa. But negligent referral, this refers to the risk that if you send a case to another attorney, you refer them a client or a potential client, and they end up screwing up the case on their end, the possible liability, the exposure for you as the referring attorney. Will that wrong client come back after you for sending them to this other attorney? Again, no cause of action in Nebraska yet. The only thing that we've had or that I've been able to locate comes under the comments to our rule of professional conduct 3501.5. states a lawyer should only refer a matter to a lawyer whom the referring lawyer reasonably believes is competent to handle the matter. Other jurisdictions have looked at this. In Nebraska, or I'm sorry, in New York, the standard is due care. In Colorado, you can see it, they have jury instructions where it's reasonable care. So while this cause of action doesn't exist here in Nebraska, as I said 8 years ago, why be a case of first impression? There's some easy steps you can take, some best practices that you can put into place to ensure that you don't end up that attorney who gets sued because you sent a client on to somebody who really messed up the case on their end. Number one, when referring an attorney on or a client on to another attorney, don't limit it to just one name. Don't limit it to Joe, who you sat next to in law school, or Mary, who you know does bankruptcy or divorce or personal injury. Give more than one name so that it's on the client to choose who they actually go with. Also, don't make any guarantees as to, oh, this lawyer will get the job done for you, this lawyer is the best, anything like that. Don't give any representations when you're sending the potential client on to a new attorney. Number two, if you regularly give, bankruptcy clients on to individual or a series of individuals, ask for their malpractice deck page. They should be able to access quickly. No reason they wouldn't want to turn that over for more business. And that gives you a little bit more peace of mind that, okay, if they really do mess this thing up, that they have malpractice to cover it, because in other jurisdictions, that's where the action for negligent referral has begun. They sue the party, or they sue the attorney that screwed up the case. They don't have malpractice, so what? They look for deeper pockets. They come back to the referring attorney who does have malpractice, and they try to institute their action there. Also, make sure that you have a list and policies in place so that your staff also knows, here's what we do if someone calls in, asks for me, and we don't do that law, and they ask for a referral. Make sure there's a set of attorneys that they want to refer to. Don't let them just, oh, I used to work for this guy, he's great, or a lady, or I know this attorney, they work well on other cases we've had. Don't let your staff send on potential clients to whoever they want. Make sure they have procedures in place. And probably the safest thing you can do is to refer anyone to the Omaha Bar Association Lawyer Referral Service. It's great. Donna over there, she's great. She can match the client up to the dozens of attorneys on the panel that practice in all areas of law. All the attorneys on the panel have to show proof that they have malpractice insurance. All the attorneys on the panel have to show proof that they are in good standing with the bar. And in fact, there are certain areas, criminal defense, domestic matters, where they also have to show proof that they have experience in those areas of law, that they've handled a certain number of cases from start to finish within the last 5 or 10 years. So I'm chair of that committee. It's a great service that the Omaha Bar offers. It can be found at omahalawyerreferral.com, or have the potential client call 402-280-3603. And that's a safeguard that we've seen in a case out of Illinois where the wrong client tried to sue the Bar Association that referred them the attorney. The case was dismissed and the court determined you can't sue the Bar Association referral service. They're not an attorney, they're just a referral service. So there's no cause of action there. A couple other quick cases. There's the Tormo-Yormack case out of New York. This one's quite old, but a New York attorney had a client, and he was actually approached by a New Jersey attorney because the case needed to be transferred out of state to New Jersey. The referring attorney sent the client on, not knowing that the New Jersey attorney was actually under indictment for insurance fraud. And then that attorney actually embezzled the settlement funds from the client. So, of course, the client sued everybody, both attorneys, and the referring attorney was found liable, actually not for his failure to know that the other attorney was under indictment, but because the other attorney should have had some red flags raised when the New Jersey attorney approached him or her, which was in itself an ethical violation. There's also Norris v. Silver out of Florida. This is in the late 90s. And actually, this was a case where the attorneys, the referring attorney and the attorney receiving the client had a fee splitting agreement, though it was oral in nature. And the court there said, yes, there can be a cause of action against the referring attorney. And they had specific statute addressing if there is fee splitting, that both attorneys can be held under their malpractice standards. Other jurisdictions, like Pennsylvania, they have not recognized negligent referrals. But again, better safe than sorry. Make sure you take the proper steps to ensure who you're sending the case to has, the qualifications, the malpractice insurance, or better yet, send them to the lawyer referral service. Attorneys cover Douglas, Sarpy, Washington, Cass County. So that's all I have for today. Thank you very much. I'm Mark Jacobs.